and gentlemen, welcome to Tokyo. Thank you very much for attending the 2023 ICN Unilateral Conduct Workshop. And for those of you watching us online, thank you for taking time out of your busy schedule to join us wherever you are in the world. My name is Kaori Igarashi from Japan Fair Trade Commission. It's my great pleasure to be the MC for this workshop. Now, let us start this program by welcoming Mr. Kazuyuki Furuya, the chair of JFTC, to deliver his opening remarks. Mr. Furuya, please.
Ohayo gozaimasu. Good morning, ladies and gentlemen, and welcome to the ICN Unilateral Conduct Workshop here in Tokyo. Today, many people from all over the world have gathered here to participate in this workshop, and we also have many online attendants behind the monitor. As the chair of the Japan Fair Trade Commission, I would like to express my sincere thanks to all the attendants and welcome you all. The JFTC has planned and organized this workshop together with other co-chairs of Unilateral Conduct Working Group, the French Competition Authority and the Spanish National Markets and the Competition Commission. Taking this opportunity, I would like to express my deepest gratitude to our colleague co-chairs. The world is currently experiencing a number of crises that threaten our economic well-being. The pandemic, war, and climate change are disrupting economies around the world. However, as the ICN Steering Group statement issued last October currently pointed out, fair and open competition, effective competition policy, and active competition law enforcement are critical components of any response to the economic crisis we face today. I hope all of us here today will reaffirm the importance of competition during these difficult times through this workshop. Against this background, the major theme of this workshop is development and challenges of competition policy and enforcement in the current unilateral conduct area. And under the theme, we will cover a variety of topics that are important for developing a competitive environment. In recent years, we have continuously discussed many issues and challenges posed by digital economy or by digital platforms in unilateral conduct area. Many of the competition issues are exclusionary or exploitative conduct by big digital platforms, and for many agencies, how to effectively address these issues is commonly recognized as a top priority. Over the past few years, a variety of law enforcement and policy-making activities are underway in many jurisdictions in order to address these issues caused by digital platforms, which have built large ecosystems in the digital economy. And a lot of experiences and new challenges have also been accumulated. Some of these activities are covered in the report of this working group project led by the JFTC, and its brief summary will be presented in the following plenary session. We will also discuss both theoretical and technical challenges regarding digital markets in other sessions. I am sure that everyone will learn a lot from the discussion in this involving field. In addition, we will have sessions on many other important topics, including good practices in advocacy activities, cooperation with other regulators, and future challenges. In each session, we invite excellent moderators and speakers who have thorough knowledge in respective topics, and they will produce valuable discussions together with the other participants. ICN is a group of rich in diversity, and workshop is forum for practical discussions. I am sure that we will have unparalleled, diverse, and in-depth discussions by bringing each other's experiences. We hope that you will actively participate in many sessions and share your challenges and approaches. Although it is still a little early for cherry blossom season, which represents spring of our country, I also hope that you will take this opportunity to enjoy early spring of Tokyo and Japan, getting warmer and warmer. Now, I would like to conclude my remarks by wishing you all the best in this workshop. Thank you very much. ありがとうございました。よろしくお願いします。
Thank you, Mr. Furuya, for your opening remarks. So now, please join me in welcoming next speaker, Ms. Pascale Déchamps, the head of union in the investigation services of French Competition Authority. Ms. Déchamps, you have the floor.
Dear delegates, ladies and gentlemen, good morning. On behalf of the French Competition Authority, I would like to express my sincere gratitude to Chairman Furuya and the Japan Fair Trade Commission for welcoming us here in Tokyo to this highly promising workshop and venue. And I hope we get the blinds up again, because for those of you who saw the view earlier, I want to see it again. So let's hope for that. I would also like to take the opportunity to warmly thank our other fellow co-chair of the Unilateral Conduct Working Group, the Spanish National Market and Competition Commission, as well as all the attendants, whether they are among us physically here or online. As Chairman Furuya rightly pointed out, all around the world, competition enforcers are currently facing challenges in uncharted territory. As we all know, the world economy is enduring significant upheavals, which are a mix of long-term trends, such as digitalization and the need for decarbonation, and short and medium-term shocks, such as supply chain disruptions, the COVID-19 pandemic, and the war in Ukraine. This troubled background has led competition agencies to reflect on how to address the ongoing disruptions and help the consumers and market recover from the effects of this different crisis. For this purpose, dealing with unilateral conduct has become increasingly critical as the market power of superstar firms, including but not limited to tech giants, has reached an all-time high. Of course, the way to achieve fair and open markets is a very complex topic, which will provide us with many opportunities to discuss and share experiences in the 2 days to come. For now, I'd like to set the tone for the workshop by highlighting 3 key themes, which run through most of the upcoming sessions. First, it is clear that competition enforcers need a comprehensive set of tools to be able to intervene swiftly and efficiently. Antitrust has long been blamed for being too slow. We have to answer by being faster and using to its full extent the diversified set of tools available in order to address each particular case with the most appropriate instrument, whether it is interim measures, commitments, settlements, injunctions, financial penalties, and a mix of those. Alternative dispute resolution methods, such as commitments and settlements, are in particular becoming more prevalent today in situations where our main objective is not only to punish exclusionary and exploitative abuses by dominant market players, but to restore the competitive level playing field as soon as possible. All available instruments, including ex-ante regulation and other legislative reforms recently introduced in some jurisdictions and being discussed in many others, should indeed be regarded as complementary. It is the task of competition enforcers to help shape those new instruments and implement them in a coordinated and efficient manner. The second theme is the one of expertise. Cases have grown more and more sophisticated, especially in the digital field. This complexity can be an additional burden for detecting practices, defining relevant markets, analyzing theories of harm, or designing adequate remedies. Competition enforcers therefore need to consistently strengthen their capabilities and expertise, for instance by hiring talented people with a wider range of skills and conducting sector inquiries or studies in order to improve their understanding of complex and fast-changing markets. The third theme is cooperation. On the one hand, at national level, the increasing complexity of the economy and the high expectations coming from politicians and consumers lead to growing interactions between competition law and other legal regimes, including sectoral regulations. Such interactions may create synergies, but also tensions between distinct sets of legislation which may sometimes pursue apparently conflicting objectives. This context entails that we, as competition enforcers, need to exchange very closely and constantly with other regulators and public bodies in order to make sure our decisions take into account a proper interpretation of these regulations and do not conflict with, but rather complement, those sector regulators. On the other hand, unilateral practices are increasingly global in scope, and as a result, the incentives have never been stronger for national and regional competition enforcers to gather and find new ways of sharing experiences, reflecting on pressing challenges and foster common understanding of the issues at stake. The ICN, which gathers competition agencies and non-governmental advisors from all the world regions, is of course an ideal place to move in this direction, and I'm really looking forward to the upcoming discussions. So on this note, I would like to thank again the JFTC, the ICN, and all the participants, and wish you a fruitful and pleasant workshop. Thank you.
Thank you, Ms. Déchamps, for your speech. So now, we would like to move on to the first plenary session. So panelists for plenary one, please come up to the stage. So the title of this session is UCWG Project Report, the analysis of theories of harm and design of remedies concerning unilateral conduct with dominance, substantial market power in the digital markets. Now, I would like to pass the floor to the moderator of this session, Ms. Reiko Aoki, the Commissioner of JFTC. Ms. Aoki, you have the floor.
Good morning. Thank you, Ariara-san. Good morning, everyone. And first of all, I'd like to thank you all for coming to Japan and to participate in this very meaningful session of the working group. And it is a great honor to introduce a project report of the JFTC, the report that JFTC undertook as a co-chair. And we're grateful to have the opportunity to discuss the main findings of the report and related issues in this session. This is not the slide I'm using. Okay. This is the excitement of being the first panel up. Oh, thank you very much. Let me just, okay. Thank you. And so we're very grateful to have this opportunity to discuss the main findings of the report, which the JFTC undertook as a co-chair. And to help with the discussion and of the main findings and the related issues, we have a very distinguished panel of speakers here today that I'd like to introduce to you. First, Chiara Bonassi, Senior Economist of the Italian Competition Authority. Alfonso Lamadrid, partner of Gary Guess. Thank you, Gary Guess. I know the firm, but I never knew how to pronounce it. And professor of College of Europe. And Dina Calais, head of competition law at Ericsson. Thank you for being here to the panel. First, the overview of the, so I first would like to take the first few minutes, hopefully 18 minutes to be exact, to give you to introduce you to the main findings of the report. So first, the overview of the project. In recent years, various competition issues have been identified and discussed within the unilateral conduct area. In particular, unilateral conduct by digital platforms has many issues. With that backdrop, the Unilateral Conduct Working Group issued a report in 2020 which focused on the analysis of dominance in digital markets, led by the European Commission. As a successor project, we conducted a survey focusing on member agencies' experiences regarding theories of harm and remedies, including challenges and approaches found in practice. We sent questionnaires to 100 agencies and 272 NGAs. 46 agencies and 31 NGAs responded. This report is a summary of those responses. First, theories of harm for unilateral conduct in digital markets. In the survey, 18 agencies conducted at least 36 enforcement actions. 8 cases out of 36 are the new forms of use of dominance in digital markets, described in the OECD report issued in 2020. On the other hand, 28 authorities do not have enforcement experiences against unilateral conduct in digital markets. According to the survey, adverse effects on consumers, such as price increases and decline in quality, i.e. consumer welfare, is not the only norm for judging the effect. Other standards were, for example, lack of an effective competitive process, decreased consumer choices, and exclusion of potential or actual competitors are considered as anti-competitive effects. When assessing anti-competitive effects, agencies frequently examined traditional factors such as extent of dominant or substantial market position, position of actual or potential competitors, and availability of alternative choices. On the other hand, two or multi-sidedness, economies of scale, and indirect network effects were considered in most digital cases. Italy, France, Canada, and EU provided cases to highlight the factors they considered when establishing anti-competitive effects. Those factors are, for example, indispensability of the service, importance of data, and unjustified reasons for safety. Agencies responded that they face challenges in 12 out of 36 cases. Here are some examples to highlight the issues. The Swiss agency provided a case to point out the challenges in assessing how the conduct decreased competition because of a set of different practices were combined into one competitive conduct. Agencies of France and Mexico mentioned similar challenges. Canada reported that the agency focused on the impact on quality and innovation rather than price in a case. The Brazilian agency replied that they found challenges in balancing anti-competitive and pro-competitive effects due to the difficulty of measuring consumer welfare in cases that MFN clauses were at issue. Challenges in collecting and assessing evidence were also identified. The Korean authority had difficulties in analyzing the details and effectiveness of revived search algorithms, but it was able to overcome the difficulties by conducting thorough investigation, such as securing internal company documents. Italian authority also reported the case regarding selection of evidence. Canada emphasized the importance for competition agencies to cooperate with other domestic regulators based on their experience of a case where a company used data privacy as a justification for refusal to deal. Remedies for addressing unilateral conduct in digital markets. Agency replied that they faced challenges in 6 cases out of 36 cases that they took enforcement actions. Though numbers were few, useful information on challenges and approaches were submitted. First, challenges regarding designing appropriate remedies. The French authority reported that they addressed the challenges to ensure the remedies would be sufficient to eliminate the conduct and remain effective in a fast-changing market. The Brazilian authority pointed out the importance of timeliness of remedies. It reported that it chose interim measures to guarantee timeliness of a remedy. Also, monitoring of remedies is one of the challenges reported. The French authority answered that to address the need for significant human resources for long-time monitoring, it designated an independent monitoring trustee. Legal or structural challenges and approaches specific to digital markets. The survey asked whether there are legal or structural challenges when bringing enforcement actions against unilateral conduct by companies with dominance in digital markets. 45 responding authorities and 31 NGAs answered this question. 40 authorities and 19 NGAs pointed out one or more challenges. 11 authorities thought it necessary to prohibit unilateral conduct that does not meet the requirements of dominance or substantial market power. The main reason is that it is very difficult to prove those requirements, so they're afraid they cannot address unilateral conduct that may have anti-competitive effects. Some responding authorities reported that they have already adopted or are now considering the adoption of legislative approaches to clarify or extend the notion of dominance or substantial market power. Here are some examples. EU established the Digital Market Act, which allows focused enforcement against concerns arising from gatekeepers. Germany responded that it has newly introduced a provision in its competition law. According to the provision, the agency can declare an undertaking to be of paramount significance for competition across markets, taking the company's market position and access to data relevant for competition into consideration and prohibits certain types of conducts. UK proposed introducing the notion of digital platforms with strategic market status. Australia and Greece are also proposing new rules for platforms. In addition, the Korean agency drafted the guidelines for unilateral conduct in platform markets. As for the scope of unilateral conduct, some responding authorities pointed out that it is difficult to address the exploitative conduct with existing legislation. To fill the gap, some of them have made new laws or amended competition laws, and others called upon the necessity of special regulator for platforms. 28 responding authorities replied that they had challenges in collecting or assessing evidence in digital markets. 21 agencies reported that analysis and evaluation of evidence are difficult. 3 agencies responded that they face technical difficulties of collecting data stored digitally, understanding of computer system in companies investigated, and lack of expertise for IT forensic capabilities. 5 responding authorities note the difficulty of obtaining enough cooperation from companies when requesting internal documents or a large amount of data. This is particularly challenging when those companies are located outside the jurisdiction and do not have local offices. In response to these challenges, it is reported that the UK established the Digital Market Unit, Australia established the Digital Platforms Branch, and France also created the Digital Economy Service. These specialized units provide developing digital tools for analyzing data required in the course of investigation and specialized knowledge. Regarding the lack of capability in human resources, responding authorities pointed out that the introduction of ex-ante regulation, earlier intervention with interim measures, and self-regulation or co-regulation by digital platforms are good approaches. In Japan, Act on Improving Transparency and Fairness of Digital Platforms has been established. It takes an approach to combine general regulatory framework and voluntary efforts by companies. The law requires designated platform operators to disclose terms and conditions to users in advance and to establish appropriate internal procedures to settle disputes. Background on lack of enforcement experiences. 28 agencies out of 46 responded they have no enforcement experience against unilateral conduct in the digital area. The survey asked 9 agencies why they did not initiate formal or preliminary investigation when they received information regarding unilateral conduct in digital markets. They reported various obstacles, including lack of sufficient enforcement experience in similar cases and lack of human resources such as economists and technical experts. They also point out that they would monitor the success of overseas authorities and liaise with them, or do not prioritize cases that a supranational authority is already investigating. Existing legal and institutional frameworks addressing companies without dominance. As we have seen, agencies point out that there are obstacles in establishing dominance and scope of unilateral conduct. 14 agencies out of 46 responding authorities have existing legal frameworks to address the unilateral conduct by companies without dominance. 8 agencies have specific provisions focusing on the imbalance in bargaining power or economic dependency. The names of those provisions are different from country to country. It includes abuse of relative market power, abuse of economic dependence, and abuse of superior bargaining position, ASBP. For example, Germany, Switzerland, Japan, Korea, France, and Italy have this type of rule. Also, 5 agencies responded that they have general provisions in their competition law that can cover unilateral conduct by companies without dominance. Germany, Italy, and Korea reported they have amended or proposed amending their laws for addressing digital platforms. Furthermore, France, Japan, and Korea reported cases that ASBP, or abuse of economic dependence, are employed. As from the NGA's view, 15 out of 31 responding NGAs are supportive for this type of regulation. 16 are not. The opposing opinions point out that unfair contract terms are generally regarded as consumer protection issues or concerns of unpredictability if dominance is not required. On the other hand, supportive NGAs mention the necessity of this type of regulation, referring to the application of ASBP in Japan. Conclusion. This report collected ICN members' expertise focusing on theories of harm and remedies, as well as the challenges they face and approaches they have taken in response. We hope member agencies find this report useful and provides assistance when they make policies or conduct investigation. The ICN's diverse membership has made this report a very meaningful one. I hope we continue to exchange information and have lively discussion to develop competition policy. Thank you very much. And as a personal comment, we know we're not, you're not alone when dealing with unilateral issues, particularly with the digital markets. Now I'd like to move on to the panel discussion with our distinguished panel here. And we'll start with Chiara, whose Italian authority has contributed a lot to this report.
Okay. Thank you very much for the invitation.
and for the possibility to share some thoughts about such relevant issues across for antitrust enforcers across the world. First of all, I would like to start from recalling one of the main findings of the report just presented, about the fact that for most national agencies, established insights on theories of harm can be carried over from other sectors to the digital one. So I actually completely agree with this view, as besides the labels national agencies apply to their digital cases, digital theories of harm actually often recall the traditional and standard abusive conducts that we already know. And for what concerns with Italian experience, the digital cases we carried out in the last years confirm this view. For instance, the Amazon case, our Amazon case, can be seen as either a self-preferencing conduct and a tying conduct as well. And for what concerns the other digital case we carried out, the Google and Elix case, this is about a refusal to deal. In fact, in this case, Google denied interoperability to an e-mobility app with the Android operating system into the car environment. So, as a consequence, the effects analysis can be carried out by means of the usual antitrust toolkit, even though adapted to fit better some specific features of the digital sector. And in particular, mostly relevant is that the starting point to build up the theories of harm is exactly the same. That is to look at the incentives a dominant player has to put in place the conduct at issue. It means this kind of analysis entails to understand its business model as well as its monetization strategy. A second remark I'd like to do by recalling again one of the findings of the report is that for most agencies, these kind of cases didn't raise particular concerns about innovation. Actually, with respect to this issue, maybe I suggest a future ICN working group could be more focused on this type of concerns, because I believe that innovation is instead crucial in this type of cases. Why? Why innovation is at the core of digital players' business strategies. Innovation leads them to, in fact, to launch new products, new services, sometimes leading to the creation of new markets. And hence, innovation is responsible for the fast evolution of market conditions. This is the reason why innovation is in general a central topic in the theories of harm. It is, in fact, it is more likely that a digital abuse stifles the innovation efforts made by the dominant players rivals. And moreover, innovation investments that a dominant player run first give it a sort of first mover advantage, allowing it to to define the rules of the games in the markets, as well as to create its own walled garden. So innovation adds some complexities to the cases. On the one hand, it is more difficult to identify the theories of harm because innovation is responsible for the proliferation of business strategies, and it makes more difficult to understand, to have some economic insights on the incentives that the dominant player has to put in place the conduct. On the other hand, innovation enters into the economic defense of the parties because the dominant player, before acting to foreclose or in general to stifle innovation efforts made by competitors, has challenged the traditional sectors, fulfilling consumer needs through the launch of new services, and it built its reputation of as a most efficient operator, providing the best services available on the market. So these are the kind of arguments that a national agency often have to face when carried out their investigations. So these kind of arguments are often used by players in order to justify their conducts. And it requires to pay more attention on finding the proper balance between competitive and anti-competitive effects. Moreover, innovation affects the remedies design because it requires to identify which objective is pursued. In some cases, national agencies have to pay particular attention in order to set remedies able to fit changes, likely changes in market conditions. In other cases, remedies should just restore the level playing field, refrained by the abuse. It means that remedies can have different objectives depending on where innovation concerns are placed. For instance, in one of the 2 digital abuses we carried out in the last years, the Google Analytics case, we try to set remedies in order to take into account the likely changes in market conditions in the near future. Because in this case, Google failed to grant the compliant, the necessary IT tools to make its app compatible with the Android ecosystem. This new app actually provided more functionalities than those provided by Google Maps, just limited to the search of charging stations for the recharge of electric cars. So the remedies were set in order to preserve innovation efforts made by Google's competitors, because Google have to provide all app developers, not just the compliant, the necessary IT tools to develop new functionalities not yet available on the market. In the Amazon case, instead, we set remedies in order to restore the level playing field refrained by the abusive conduct carried out by Amazon. This was a case in which Amazon has leveraged its market position in the market for marketplaces to the market for logistics services for e-commerce. In this case, Amazon granted a set of exclusive benefits in terms of more visibility and more sales to third-party sellers choosing the logistics services of Amazon. Instead, third-party sellers did not choose the logistics services from Amazon, had to comply with a set of strict quality standards in the delivery services. And this clearly put the Amazon's competitors at disadvantage. According to the Amazon defense, the investigation could distort the innovation incentives of the platform because Amazon claimed that had to define the strict quality standards in order to safeguard the overall quality of the services provided to end users. And it could not fully monitor the fulfillment of these standards if the logistics services were provided by third-party logistics operators. But this was not actually our point. The Italian agency did not dispute the right and the incentives for Amazon to set high-quality standards. What we disputed was that, by definition, only Amazon could comply with these rules, quality rules. And so the remedies were set in order to make Amazon to compete on the merits, allowing sellers to meet those standards regardless of the logistic operators they choose. To conclude, I believe that innovation is a quite relevant issue that has to be managed carefully in order to build up a proper theory of harm and to design remedies that are effective and coherent with innovation concerns come up under the investigation. Thank you very much.
Thank you, Giara. That was very enlightening, particularly the Amazon case I personally found very interesting. And now on to Alfonso. You're a lawyer and a scholar, so could you give us your views on the issues raised in the report?
Thank you very much. Thank you. Good morning, everyone. Thank you, Commissioner Aoki. Many thanks to the Japan Fair Trade Commission for your hospitality and to the Spanish Competition Authority for their invitation. So I'm very pleased to discuss with you this report that I believe shows essentially three things. First, I think that it shows that you all share a common understanding of the main theories of harm that apply in unilateral conduct cases in digital markets, and that you're not shy of developing new theories. Second, I think it shows also a common perception that you feel that your job is becoming increasingly more difficult, that theories of harm are becoming more complex, and the remedies are becoming more intrusive, and that this places more of a responsibility on you. And third, I think it also shows a concern about the sufficiency of standard antitrust tools and remedies to address some of the perceived harms that occur in digital markets. So my personal thoughts on the report, all within the theme of international convergence, which I think is why we're here, revolve around three main points. So one is the notion of harm, the notion of anti-competitive effects. The second will be around the assessment of pro-competitive effects. And the third topic I want to discuss is the risk of regulatory fragmentation. So first of all, a quick disclaimer. Commissioner Aoki, you said I'm both a practitioner and an academic. Here it says College of Europe. And while it is true that I teach at the College of Europe, my views are mostly those of a practitioner. I hate it when practitioners use the academic hat to pretend they are neutral. That's not my case. I am neutral when I teach. I am not neutral when I'm a lawyer. There's no neutrality obligation yet for lawyers, unlike for some digital players. So my experience and my views are certainly colored by what I do. And part of what I do is represent some of the large technology companies that you were talking about. I represent Google before the European courts in the Google Android case. I also advise Google in the Google NLX case in Italy, but I will not be discussing that. I also represent CCIA, an association of large technology companies in the Google shopping proceedings before the Court of Justice of the European Union. But my views, as usual, are not of those of my clients. I have not discussed any of this with my clients, at least not for today, nor those of my firms, and certainly not those of the Spanish Competition Authority either. So going into substance, the first point I wanted to discuss, the notion of anti-competitive effects. So as Commissioner Aoki explained very well, the report essentially discusses the identification of the main theories of harm that you can use to prosecute cases, and also the remedies that you can use to address competitive harms. Now, both the theories of harm and the remedy will need to match with the competitive harm. So in any given case, before you think about the theories of harm to prosecute the case, and before you think about remedies, you think to identify where is the competitive harm. So the first point I wanted to make, and it's rather a question, is do you all share the same view of what competitive harm is when it comes to digital markets? So do we all mean the same when we talk about anti-competitive effects in unilateral conduct cases in digital markets? I think this is very important because this is essentially the bottom line of what you will need to prove in any given case. And it appears to me that right now there are different interpretations of what constitutes harm or when that harm warrants competition law intervention, particularly when it comes to unilateral conduct in digital markets. So I'm not referring to the question of probability or likelihood. I'm not talking about this debate between capable or likely that we have in Europe. I am not talking about the standard of effects, about the standard of proof. I am talking about what actually constitutes an anti-competitive effect that warrants the intervention of a competition authority. So the report touches on this point, so section 2.3.2, and it says that responding authorities took a wide view of what could qualify as an anti-competitive effect, including, I read, adverse effects on consumers, such as price increase and decline of quality, lack of an effective competitive process, decreased consumer choices, restriction of freedom to trade, reduced innovation, exclusion or foreclosure, or limiting competitors' ability to compete. So I think this all makes perfect sense. This is all correct. But the problem is that you can interpret all of this in multiple ways. You can subject this to a very high threshold of effects or to a very low threshold of effects. So for example, do all practices that give a dominant firm a competitive advantage result in competitive harm? Or do all practices that create an inconvenience to a rival create competitive harm? So I think the question must necessarily be no, because otherwise a dominant company could never compete. But then the follow-up question is, so when do an inconvenience or a competitive advantage become a competition law problem? Because they can certainly be a competition law problem. So, and in turn, this raises another set of very interesting questions. So do authorities always need to examine coverage? Because that is closely related to a threshold of effects. Is there any relevant threshold of coverage? Do you need to show foreclosure or capability to foreclose? And do you need to show foreclosure by reference to an as efficient competitor, by reference to an as attractive competitor when costs and prices are not involved? And paraphrasing a well-known Japanese writer, what do we talk about when we talk about foreclosure? So I am not sure that we have a shared answer to any of these questions, and I think these are key. I have my own views, but again, I'm not here to try to persuade you of anything. I'm here to try to spur some debate within the ICN, and if you, one of the questions we got is, what should we focus on in the future, how to follow up on this report? In my mind, this should be an area where further ICN work would be most helpful. Now, the second question I wanted to touch upon is the question of pro-competitive effects. And here, I think there's an idea that is very important to convey. So the report observes that authorities take into consideration, Commissioner Aoki mentioned this, a wide range of factors when it comes to the assessment of anti-competitive effects. And in the case of digital markets, we all often refer to multi-sidedness, network effects, economies of scale. But at the same time, the report says, and I quote, "In contrast, factors for assessing pro-competitive effects were not always taken into account by the responding authorities." Now, to me, this was very striking because in my mind, the very reason why your job in these markets is so difficult, much more difficult than our job, I would say, lies precisely on the fact that the same features and the same market characteristics that can give rise to concentration, market power, anti-competitive effects are, again, precisely the same features that create value and pro-competitive effects. So there are many economists in the room, and as you know, all of those factors, network effects, economies of scale, they are positive externalities. They do create value. So particularly in platform settings, the very role of the company who wants to create value for users is to maximize those positive externalities and to minimize negative externalities. So what happens, and what I think is a real challenge for you in these markets, is particularly again in platform scenarios, is that the same rules or the same practices that may appear to restrain competition may actually in practice enhance competition. That's what is tricky. And you mentioned in your presentation an example, a Brazilian case concerning MFN clauses that Kare pointed to. I think that's a very good example. So this is one of the debates that arises in MFN cases, and that's what really complex. Now, when you're faced with one of those cases, what should you do? So does the problem lie in having to balance pro-competitive effects and anti-competitive effects? How do you do that? So as far as the European Union law is concerned, the European courts have already addressed many of these questions, arguably not in a 102, so not in a unilateral conduct scenario, but in Article 101 cases, so concerning agreements, particularly concerning credit cards and payment systems, so cases like MasterCard, Carte Bancaire, Budapest Bank in particular, and the courts have acknowledged what I was saying earlier. So in these settings, practices that may appear to restrain competition may in fact enhance competition. So what do you do? Do you do a balancing at the end of the analysis to see whether those pro-competitive effects outweigh anti-competitive effects? Well, that's something that you need to do. But from a practical standpoint, I don't think that's the most complex part of your work. Because at that point, the dominant company has the burden of proof. So they need to show, they need to do that assessment, and they need to prove to you that pro-competitive effects outweigh the harms. I don't think that's where the challenge for you lies. I think the challenge for you lies at a prior stage when you need to assess the counterfactual. So what does that mean? When I often talk about the counterfactual, people believe that it sounds scary. It's like one of these tricks that lawyers of large companies like me will try to pull to make life difficult for you. But that's certainly not the case. I think the counterfactual assessment is the bread and butter of competition law work. You do counterfactual assessments all the time. You do them in any merger case, in any 101 case. You do them concerning any vertical restraint. I think vertical restraints are actually a very good example because many of them are presumptively legal, even if they may restrain intra-brand competition. Why? Because they are deemed to foster, enhance inter-brand competition. So within platforms, exactly the same logic applies. Now, when people talk about this, we tend to exaggerate and say, well, then you're saying that we need to make hypotheses about all possible courses of conduct to see whether the same effects would occur. That's not what I'm saying. I think the job for you, and I don't think in most cases it should not be a problematic work, is to say, look, absent the restriction, would there be more or less competition? Meaning, is there any realistic or likely scenario in which absent a practice, there would be greater competition? And again, in most cases, the vast majority of cases, I don't think you would have any problem running that exercise. And I think this is also what ensures that there's no risk of over-enforcement. So some authorities in the report also pointed to that risk of over-enforcement, flagging in particular two things. So one, the vagueness of the competition law provisions, which goes back to my first point, and then the difficulties in running this balance. So again, I don't think I think you do this all the time, and it should not be much more difficult in these settings than in any other settings. Now, the third point I wanted to address is the risk of regulatory fragmentation. So I think that's a risk that is particularly acute when it comes precisely to digital markets and to unilateral practice. And I think that if we all are here in this room today, it's because we place great value in international convergence. It may also be because we wanted to visit Japan, but I think we also place value in international convergence. So I think there are three sources of risk for regulatory fragmentation that I think we need to be aware of. One, which may be a bit specific of the European Union, occurs when authorities applying the same set of rules do so using different substantive criteria. I think to some extent this is okay because authorities, I think it's part of your job is to push the boundaries. I think that's perfectly all right, and I can understand perfectly why there is a temptation to try to stretch things or push or test the boundaries in this kind of cases. And in principle, I see nothing wrong with that. But I think it is a problem when that leads to the emergence of multiple different substantive standards that we need to work with in each jurisdiction. Second, I think there's also a problem, and you've alluded to some of this earlier in a way that I thought was comforting. I think there is a problem of fragmentation when we try to apply different rules only for the digital world or only for some players in the digital world. So when we send the message that the rules that apply to others are not the rules that apply here. I don't think we're necessarily there yet, but I think that risk may exist at times. And third, I think there is a problem of regulatory fragmentation when, due to the enactment of multiple legislative instruments to tackle different practices. So the report notes that many of the responding authorities call for brand new legislation or amendment of the competition law rules to fill the perceived gaps. So I've never been entirely sure of whether those gaps exist, but that is beside the point or perhaps even a lost battle. But I think my message is the following. So I think those ex-ante rules like the DMA, which is often cited and as an example, might certainly make it easier to reach a particular outcome. So they will make it easier to successfully have structural or behavioral changes in the market. And you can be sure that they're much easier for you to apply. So in a DMA world, for example, you would not need to discuss dominance, you would not need to discuss the counterfactual, you don't need to discuss anti-competitive effects, you don't need to discuss pro-competitive effects, so you won't need to discuss anything of what we're doing, what we will be discussing here. So arguably, under a DMA world, in a DMA world case, I'll finish now, there will be no reason for any of us to come to Japan or other nice places to discuss the difficult stuff. So I think there is a reason why over decades the law has moved to the careful assessment of practice on a case-by-case basis. I can understand why that is very difficult for you. I can understand why it may often be frustrating for you, but I would submit it is much more helpful to reach the optimal outcomes. Thank you.
Thank you. Thank you, Alfonso, for your honest comments. As an economist, I feel like I should jump in and clarify some of the confusions you might have and go back to Chiara, but instead I should go to Dina. So your comments, please. Thank you, Alfonso.
All right. Ohayou gozaimasu. This is my first international ICN workshop since COVID-19, and I cannot think of a better place to have it than in Japan. So thank you for having us. It's delightful to be here. Before I start, I should just clarify that I'm actually here in my hat as an NGA for the Swedish Competition Authority. And actually, more generally, I think I'm here as part of the ICN community, as is indicated by my ICN lapel pin. So, although it has my employer's name here, I'm here in the more broader ICN capacity. The second preliminary remark I wanted to make is to congratulate the people who wrote this report. I was the lead author of actually the first UCWG report, the one on goals of unilateral conduct in 2007. I know how much thankless work this takes. It's a very helpful stock-taking report, 108 pages, so congratulations to the authors on a great job and on a report that I think will be very helpful for all of us. I also wanted to mention in my ICC hat that we intend to discuss this report at the pre-ICN conference in October in Barcelona, so we're going to have an opportunity for the private sector to talk about it. Now for my general remarks. So I guess there's a predicament to going third because you somewhat repeat what people have said before, but I would start by indeed observing that in more than 3/4 of the cases in the report, 78%, 28 of 36 cases, the agencies were able to rely on traditional theories of harm to address the conduct. And that's a great sign. I think it's a good sign that our regular, competition law analysis theories work, and we don't have to reinvent them every time there's a new industry. And then still, in about 1/4 or 22% of the cases, there were new theories of harm that were utilized. And in that context, I would make two asks, I guess. The one is that if and where new theories of harm are used, there's guidance provided, ideally earlier on, about, this is now a new theory of harm that the agencies are going to apply, because for us, the in-house people who are we're really working with competition enforcers hand in hand, right, with what agencies call enforcement, we call compliance. So in order to achieve a good success in that, it's very helpful for us to have guidance and know what is considered a violation by agencies at any time. And the second comment, and I think along the lines of what Alfonso just said, is that I think the ICN should consider creating harmonizing work product in this area. Because if you're a multinational doing business in 180 countries, it's impossible to comply with 180 different standards. So I think it would be helpful for the ICN to provide guidance on, especially on new theories of harm in this area. My second remark has to do with the fact that indeed the majority of the cases applied a rule of reason approach, balancing any pro-competitive effects with anti-competitive ones. That's obviously extremely useful, especially in unilateral conduct cases where it's very difficult to distinguish between hyper-competitive, legitimate conduct and conduct that is exclusionary or illegal. So I think that's a good principle for agencies to utilize. The third thing that was uncovered in the report is the growing importance of non-price effects. For example, in the Canadian Toronto Real Estate Board TREB case that we saw in Commissioner Aoki's slides earlier, there was a focus on the effect of quality and innovation. The NGAs that responded also zoomed in on non-monetary effects like increase in non-monetary prices like data, and reduction of quality and harming innovation. I think that makes a lot of sense. I mean, competition was always not only about prices, but now it's even more so because we see non-monetary currency, in cases. So I think that's helpful. My fourth comment and last one will just touch on the capacity constraints. Indeed, I mean, when I was young and child-free, I worked on the Microsoft case at the Commission, and I remember we once counted, and there were 7 people on the case team and about 2,000 in the law firms working on the other side. So there's definitely a capacity issue. The report suggests that private litigation could be one way to balance it out, and I would just probably comment that when you're litigating in private litigation with companies in that magnitude, the depth of the pockets make it very difficult. So I wouldn't count that much on private litigation. I just think it's difficult because of the difference in pockets and resources. And it's something we have to keep in mind. I think I'll stop here and then I'll wait for the Q&A. Thanks.
Thank you, Dina. It's very interesting. The Microsoft case often comes up again whenever we start talking about digital economies. I think we are always learning about this topic. Now we'll go on to the Q&A session. And although, Alfonso, you already mentioned the interpretation of competitive harm and the anti-competitive facts, but could you focus on EU law and explain to us how it works?
So thanks very much. So I think in EU law we also struggle with some of the questions, or we're still debating some of the questions that I mentioned that also arise at the international level. So whenever you have to advise a client, let's say, even on these new theories of harm, but also on some traditional theories of harm, first you need to be sure what the standard is. What's the bottom line? What's the threshold of effects? And very often that's difficult to do. So, for example, I have to advise now on platforms on self-preferencing cases. And when is self-preferencing a problem? So under the DMA, it is always a problem for some players. Under competition law, it is unclear. So, for example, the Google Shopping decision does refer to a possible risk of foreclosure. There are other decisions at the national level that do not necessarily refer to that. There are some decisions opening cases that talk about the fact that there's a competitive advantage. So that's unclear. So I think I would distinguish three dimensions. So first, what the case law says, then what the Commission is doing and what the Commission committed to do, I would say, in the guidance paper on Article 1 and 2, and then what happens at the national level. So I think if you look at the European courts, there are some judgments, particularly on pricing cases. So Intel, Qualcomm, that say the standard is foreclosure capability to foreclose as efficient competitors. So that's what we have, what the EU courts have said for pricing conduct. Now, for non-pricing cases, I don't think this is as clear. So, for example, in the Google Android case, where again I am biased because I'm active there, that's a tying case. The court says, well, the test is capability to foreclose, which is not what the decision has said, but it says capability to foreclose, but with a different meaning than in pricing cases, because you do not need to consider whether rivals are as efficient or as attractive. So it's a different, let's say, arguably different test of foreclosure. And then you have other judgments from the European courts that do not necessarily talk about foreclosure. They say that it is capable of restricting competition, and very often they add in particular by resulting in foreclosure. So again, we still don't know what the actual test in some of those cases is. Then back in the day, some years ago, I think the European Commission made a very helpful effort to provide certainty in this area, and they said, well, in principle, as a matter of priority, we will apply a test of anti-competitive foreclosure across all cases. So that means a situation where effective access to the market is hampered or prevented in a way that will end up harming consumers. So in many cases, the Commission has applied that standard post-guidance paper, not in all of them. So the foreclosure standard was not applied in, I believe, Qualcomm, certainly not in the Android decision. Again, whether that's a good or bad thing, I'm not discussing here. I'm not here to discuss. And then, so I think you can see different standards in different decisions, which, regardless of their legality and of whether that's right or not, I think that is a problem because we don't really know what's the standard that applies for every given practice. And I think the same, or the risk is exacerbated if you look at the national level. Frankly, not in Spain, where I think the Spanish authority has been a prudent and sensible enforcer in this regard. But there are also other member states, and I won't name names, where you can see that different thresholds are being used, and that may be a problem.
Thank you very much for giving us a very good overview that it's a very difficult area. Thank you. And now let me move on to remedies, which was the second theme of the report. And Chiara, what are the challenges when designing remedies in markets where innovation is a key? You touched on innovation in the presentation.
Yes. Yes, actually, in my opinion, in my view, remedies, one of the most important things is that remedies should not come up from scratch, but they should start from solutions already implemented or being considered by the parties under the investigation. And this kind of approach allows, I believe, national agencies to put in place, to set remedies that are administrable and at the same time effective without being disproportionate, because they come up from parties' solutions. This is the approach we followed in the digital cases we carried out. For instance, in the Google NLX case, Google had developed a beta version of a new template allowing the mobility apps compatible with the Android ecosystem. And under the investigation, we found that this solution was the best solution, better than others, for instance, with respect to customized apps. So also in the Amazon case, in the definition of remedies, our starting point was an experimental program that Amazon had carried out under the investigation, allowing third-party sellers to have access to the exclusive benefits without choosing logistics services from Amazon. And in the remedies design, we obliged Amazon to make some changes in this program, according to which Amazon had to qualify, had to select which sellers could have access to this kind of program. And we asked that Amazon didn't have to select the sellers, but Amazon would have to give access of all the third-party sellers that could comply with the quality standards the platform had set. And another provision we asked to drop was about the fact that, according to this program, Amazon had to play the role of intermediator between the sellers and the logistics operators, defining, setting the price and the commercial conditions. And we asked Amazon to drop this rule in order to make this program more effective. So the message is that in general, it should be better if a national agency should start from solutions already considered within the parties. This allows to make the remedies more appropriate, more effective, without being disproportionate.
Thank you, Chiara. And do you have anything to add, Tina? And particularly because you were nice enough to cut your presentation slightly short to keep up with the schedule. If you want to add anything, please feel free to do so now.
Thanks. No, I'm good. On remedies, I would, I agree that the design of remedies in this area is a challenge, especially timeliness. You know, it can take years for the decision to come out, and then maybe the result could be irreversible at that time. So I would have two suggestions in terms of better remedies in these type of markets. The first one is for agencies to think about advocacy as a tool in the toolbox, as a soft remedy. What you pronounce and say in speeches and policy statements, press releases, etc., does make a difference. And that can be done, you know, before the case is completed. It can convey your agency position on, you know, what is legal or illegal, and and it has an effect in the outside world. So my first reflection would be to suggest that advocacy is really a soft remedy tool that you should consider using. The second thought is an idea that I've heard discussed before in other sort of group settings, and that's the idea for unilateral conduct to have some sort of, for unilateral conduct cases, to have some sort of aspirational timeline. You know, mergers, they should be done within 30 days in most jurisdictions, but conduct cases can take 10 years. And there's no point in having a case that, I mean, I can tell you from experience that I have a case that is near 10. I mean, maybe it's good if you're in the law firm business, but for agencies and for in-house companies too, I mean, you don't want your resources tied up to a case for that long. So of course you have to balance it out with the need to allow for companies to defend themselves. But I think it'd be interesting to toy with the idea of having some sort of aspirational timeline for unilateral conduct cases, so that they don't last for many years. That also can help help agencies. If maybe they don't have enough evidence or they don't think they can bring the case, fine. They close the case. If they have enough, they bring the case. But it's efficient, right? We're all about efficiency. We're antitrust lawyers, so I think in terms of remedies, it's important to think about an aspirational timeline. That's it. Thanks. Onegai shimasu.
Thank you. Arigatou gozaimasu, Dina. And Alfonso, do you have anything about remedies, particularly in digital markets?
No, I think designing remedies is also a very tough job that you have to do. I don't underestimate the complexity that this entails. I tend to think that commitments and negotiated solutions are often the best alternative, because that's what ensures that the remedies are, I mean, in principle, they can be disproportionate by reference to the harm, but I think that's also what enables you to shape competition going forward. I think Pascale alluded to this also in her introduction. I think those negotiated solutions are perhaps the most helpful way for authorities to have a say in how competition develops going forward. I think they are quite helpful. I've seen them be more helpful than, let's say, more prescriptive remedies in other scenarios.
Thank you, Alfonso. And Chiara, now we move on to the technical difficulties that authorities face. Do you have any comments on that aspect?
Yes. I would like to highlight the importance in facing these digital cases and the remedies, the implementation, to involve third parties in order to fully monitor and oversee the implementation process of the remedies. I think that this is a solution in order to make the remedies timely and effective. This is a solution we adopted in the Google and LX case, in which we selected a monitoring trustee, and it was actually the compliance with the remedies was a successful phase, as it ended up in less than, I think, in less than 1 year. So it's quite important in these cases where technical issues are relevant or crucial. Another solution I could suggest is to think about an organizational change in order to build up digital units specialized in this sector. Because it's quite important to develop the necessary skill to better understand the markets, to understand which strategy, which business models and monetization strategies are most widespread in the sectors concerned. Thank you.
Thank you, Chiara. Now, this will be the final question I'm going to Dina about what you would like the future ICN guidelines or products to do. But perhaps you could also answer one question that's come online here from Charles McConnell of Global Competition Review. And he asks, Frederick Jenny at the OECD recently said that antitrust authorities have stopped prioritizing enforcement in digital markets as other concerns have arisen. Do the panelists share that view? Seems like that this is not the case given the report and the discussion so far. So when you talk about what you'd want, like ICN guidelines and products to be in the future, perhaps you could answer this question or give your personal view on this at the same time.
Can you just look at his question for a second?
Sorry.
Is the question, where is it? Here. Fred Jenny said that.
Maybe you could read it out
Yeah.
if somebody else wants to jump in after you.
Sure. I'm just going to reread it because I didn't follow. It says, Frederick Jenny at the OECD recently said that antitrust authorities have stopped prioritizing enforcement in digital markets as other concerns have arisen. Do the panelists share this view? Seems like that is not the case given the report and discussions so far. Thanks. So I can start. I can answer my question and I don't know, maybe. Not sure I'll answer the journalist's question because I have to keep my job, but let's see. So you've asked me, Commissioner Aoki, whether I have any suggestion for ICN work product in this area. And yeah, I do. It seems that the two most common theories of harm in this space are emerging to be most favored nation and self-preferencing. That's both in this report, you know, that discussed, for example, Kajes, Decolar, and Booking.com, which was an MFN case. And there's also a 2020 UCWG report on digital markets that identified these as key lead theories. So I think it'll be very useful for DICN to produce harmonizing and you know, guidance-enhancing documents in these two areas, because that will give us a global converged view of how to address these issues. On the question from GCR, maybe I'll let my panelists start and maybe I'll follow after them.
So in my view, not at all. I think competition authorities continue to be very focused in digital markets, but they have you have many more things to do. And I think that's only natural. The digital markets is not they are not the only markets in the world. They may not be the markets where there are greater harms to consumers. I think there are markets that raise interesting issues for you, and certainly you need to look into those. But I think there are citizens, consumers have other priorities. I can see, for example, in my member state in Spain, the authorities are also very focused on energy. I think that makes a lot of sense. That doesn't mean that authorities are not looking at digital markets. I think the focus is very strongly on digital markets, but I think the competition authorities need to react to the most urgent matters of the day while paying attention to others. So I think certainly I have not seen that shift. I've only seen you guys work much more on multiple different fronts.
Thank you. Do you have anything? No. Okay. Well, I think I'd like to thank the panelists for cooperating with the timekeeping. Thank you very much. And thank you for the audience. I'm very sorry I was unable to take your questions, if any. But perhaps you could talk to the panelists during the coffee break. Thank you very much.